question, then read out the answer. By the time that you are resuming, we will be on the same page. So, projected deliberately on week 8 of...
Okay, Victor, I am done.
Okay. Background sound iko sasa sawa?
Iko sawa.
Nice. So I've started with one of the questions in the course outline. Kindly discuss or give out the forbidden agreements under section 46 of the Advocates Act. Or in general, what are some of the agreements that an advocate is prohibited in entering into?
Hapo umenikama.
So many quick overview of the course outlines. Deliberate questions. Bila kuficha.
Nishaangalia hii ama ni agreement yenye where you promise the client that you will achieve a particular outcome, and if you don't, then they are not supposed to pay you the legal fees. But I'm not sure. I'm just guessing.
It's good to try, Kista. Hapa tuna learn. So even from the topic itself, you have correctly deduced one of the forbidden agreement is a chaplaincy agreement, where you have an interest in that matter. That is prohibited.
Chaplaincy.
Chaplaincy, yes. Yes. Okay, can I sort something? Acha nilipie kitu tu hapa inahitajika urgently. As you open section 46 of the Advocates Act directly.
Okay.
Yeah, juu kuna other agreements. So, Kista, have you managed to open section 46 of the Advocates Act?
I have.
Okay, what is it saying?
Oh, I read it verbatim.
Yeah, so hata mimi nime wrong.
Okay, so it's saying, nothing in this act shall give validity to any purchase by an advocate of the interest or any part of the interest of his client in any suit or other contentious proceedings, or any agreement relieving any advocate from responsibility for professional negligence or any other responsibility to which he would otherwise be subject as an advocate, or an agreement by which an advocate retained or employed to prosecute or defend any suit or other contentious proceedings stipulates for payment only in the event of success in such suit or proceeding, or that the advocate shall be remunerated at different rates according to the success or failure thereof, or any agreement by which an advocate agrees to accept in respect of professional business any fee or other consideration which shall be less than the remuneration prescribed by any order under section 44 respect of that business or more than 25% term of the general revenue recovered less the party and party costs are taxed or agreed, or any disposition, contract, settlement, conveyance, delivery, dealing, or transfer that is under the Insolvency Act void or ineffective against the official receiver or a bankruptcy trustee or an interim trustee in proceedings under the Act. So ni hizo tano.
Good. Now your takeaway, Kista, yani the key takeaways. What kind, yani briefly? Number one, if you state in statement form in a layman's language.
Okay, the is the one I had stated earlier, where you as an advocate you enter into an agreement with your client, stating that they will pay you only when you succeed in the case, or they will pay you a particular amount if you don't succeed. And then the other agreement that is prohibited is where you enter into an agreement with the client to undercut, whereby you will ask for remuneration which is less than what is supposed to be remunerated under section 44. And I don't quite understand, mostly for Insolvency Act, the one under 46E. The first one. Okay, and then the second one, kuna hiyo ya kwanza, where an advocate can't enter into an agreement to purchase their client's interest in a suit or other contentious proceeding. But sasa hiyo itawakaje? Kwa instance gani ndio advocate anaweza taka kupurchase interest ya client in a suit?
It can happen where they are filing maybe bankruptcy petitions, alafu ana act to the detriment of the company because akona a certain percentage yenye maybe amepromisiwa. If we quickly close this company, kuna a certain share yenye utapata, lakini majorly nimeona ikiwork in conveyancing deals where a client anakuapproach ana pesa, then anasema atakugawia kashamba. Hiyo ndo the practical nimeona ikihappen. So the main reason pia nimekuambia we understand that provision clearly is because failure for us to understand, unaweza letewa situation where an advocate ame draft one of the agreements yenye iko hapo. Alafu iko fatal. Now nimejaribu to break down for us to understand easily. Tukienda charge vizuri. Haya, so let me give you the full explanation. Inasema one, if you read section 45 of the Advocates Act, ndio inasema that an advocate should have a retainer, and unapata a situation where you will engage in an agreement yenye ni undercut, that agreement will be invalid. At least that point umeielewa vizuri. Then we have where an advocate is buying a client's interest in litigation, imekuwa prohibited venye tu tumesema hapo. Then kuna hizi za kuguarantee a winning, zinaitwa contingency fee agreements. So una contingency fee agreements ni different na championship. So hizo ni ziko prohibited. Contingency, one of the example venye inatumika ni wewe unasema the client shall pay the advocate only if the claim succeeds. Hiyo wanaweza kuwekea hapo deliberately for you to fail. Then agreements where fees vary depending on success or failure. Hii tumesema ni hiyo ni repetition. Agreements for fees below the prescribed scale, hiyo tumesema you charge below the prescribed scale. Then kuna agreements exceeding the permitted percentages of damages. Hii sasa ni technical na let me break it down. Unapata kuna some entitlements zimewekwa na the law, zimeitwa statutory limits na ina apply sana sana kwa personal injury matters. For instance, it is illegal for an advocate in a personal injury matter to agree to take 40% of the damages recovered because that will be vulnerable. This is the reason. The law caps recovery for general damages on behalf of the advocate. Sasa anafaa kupata 25%. Okay, and this 25% you have less party and party cost as taxed or agreed. Now, acha nikubreakie down vizuri Kista. Wakati unachukua instructions from a client to do a road traffic accident claim, huo una sign na yeye kitu inaitwa fee note agreement. Na hiyo fee note agreement maybe umeandika pale percentage fulani yenye utarecover after umewin the case ama not winning the case, either way winning sasa yote nani contingency. Sasa hapa sheria inasema you are only eligible to recover 25%. Wewe umeenda pale ukaandika 40%, a very potential scenario yenye inaweza kuja. So section 46 of the agreement of the Advocates Act may directly prohibit that kind of an agreement where you want to obtain more than 40 na hauja less even party and party costs. Now, yenye umesema huelewi ni hii yenye inaitwa transactions will be invalid under bankruptcy or insolvency law. This applies where, for instance, let me give you an example. A bankrupt client transfers property to an advocate as fees in a manner that will be void against creditors or a bankruptcy trustee. Section 46 will not save that transaction. Unaelewa hapo sasa Kista? In that the acts that are conducted by a bankrupt client to defeat the ends of justice, even if your property imekuwa transferred to an advocate, that agreement will not survive the day. So those are the 5 forbidden agreements zenye unaweza ulizwa on your feet na inaweza kuja from an examination situation. Now, Kista, I have another question bado in regards to professional ethics. An advocate amemaliza a case, but this advocate anasema this client has not paid my legal fees. Haya, client anasema advocate afai kukomilia my money because of one reason. Kuna reason yenye client anasema the law says no advocate should have a lien over a client's property kama hajafanya kitu fulani. What is this thing yenye advocate anafaa kwanza kufanya ndio akuwe justifiable kushikilia ile property ama ile funds zenye zimeingia kwa account ya client?
Okay, I guess the right of an advocate to lien na hiyo ilikuwa inaitwa charge order. Ni charging order, charging order. But sasa kwa hiyo charging order kuna exceptions when inasema you are not supposed to hold a client's money. So here at least ina fall under the exception of what an advocate can hold as lien. What I understand can be held as lien by an advocate is the file that belongs to the client, the document of the client, but and other things, but money doesn't fall under the.
Good. Kista, Kista, you have made
Acha ni confirm iko section gani?
Okay.
section 52 52 ina provide for charging orders, but ingekuwa ni document yenye inaweza kuwa held in lien by an advocate, then huyo advocate lazima kwanza asik permission from the court. Huyo yenye anafanya through making an application by way of chamber summons under order 52 rule 4 of the civil procedure rules, and then kwa hiyo application ni chamber summons, and then una supporting affidavit, I guess, but siko quite sure. Ndo usiki kwanza permission of the court ya kuhold hizo property in lien of payment.
Thank you, Kista. By the time that I'm asking you that question, I'm targeting to see whether you will understand one of the exceptions to the rule. Money can also form part of a lien and an advocate should anaweza shikilia, but this is the rule. Unaona nime project hapo kitu. No lien before taxation of a bill of cost. You can't be justified as an advocate kushikilia property yoyote ya client hata kama hujakulipa legal fees kama huja tax bill of cost. That is what decisions say, na hata ukisoma hiyo decision iko hapo is the one to give you the answer. I was listening keenly kuona kama utasema about taxing before you hold lien of a client's money. Now acha nikurudishe mahali hapa hiyo ni professional ethics. I want to go across board. Even Albert, welcome. So pia Albert umeform part of the potential members when utakuwa unajaribu question. What am I looking for? Nataka kuchukua moja ya LPM hapa. Hizi nauliza. Yes?
Pesa ina form vitu zenye zinaweza kuwa held by a client.
By an advocate. Yes. Yes, after a tax a bill of cost. It is allowed. Albert can confirm.
Yeah. I understand hizi lien zote lazima ukuwa umetax. But money ina fall kweli under hiyo lien.
Yes.
Tukifunga walikuwa wanasema hiyo lien does not extend to funds held on behalf of a client.
Good. Funds held on behalf of a client, but after umetax kuna pesa yenye koti itasema belongs to an advocate. Utakuwa umefanya advocate client bill of cost. So utakuwa justified kushikilia pesa yako, kushikilia ile, yani sijui ndakwambiaje, umeshikilia kama lien in case alete complaint. It is a defense to say that you have already taxed the amount. Now you are willing to remit the client's funds. Hiyo ndo the rationale ninajaribu ku bring on board.
Okay.
Yeah, nimekupata. You can't generally shikilia kila kitu. Yeah. Now, Kista, I believe you have been taught about the Bangalore principles of judicial conduct. Can you give us maybe 3 principles of judicial conduct from this Bangalore principle? Even Albert, you can attempt. Nimetoka kwa Kista. Let this go to Albert. Albert, you can give us, if you are in a position, maybe you can declare you are in a position. Have you read the Bangalore principles of judicial conduct? Kama Albert yuko around, Kista, you can try it out. Just 3 principles from the Bangalore principles of judicial conduct.
I deal with the conduct of the judicial officer, but on the principles, if I try, number 1, the judicial officer is supposed to be impartial. Number 2, if there is any issue that can bring about impartiality, then the judicial officer is supposed to declare and report the same. And number 3, if the impartiality is manifest, then the judiciary officer should recuse themselves. I believe that can be an answer. I'm not quite sure.
Thank you so much, Krista. I can read out the answers from my end. Umepata majority: independence, impartiality, integrity, propriety, equality, competence, and diligence. So I can repeat: independence, impartiality, integrity, propriety, equality, competence, and diligence. Those are the principles that are borrowed from the Bangalore principles of judicial conduct. So maybe you can also try out another question that is frequently asked. Krista, do you know how to do opening statement or closing statements? Let's start with opening statements. What are the key features of an opening statement if you are told to do one on your feet? What are these essential ingredients that you will look at?
Okay. In an opening statement, you're supposed to first introduce yourself. Who are you and who are you acting for? After which you're supposed to give a brief introduction of the facts of the case, what the case is all about. And then you can also speak to the evidence which you will rely on. In this sense, you are supposed to introduce let's say the number of witnesses you will rely on to buttress your case, and the documentary evidence maybe which you will rely on. And then you are supposed to briefly outline the strengths of your case and also the weaknesses. Now when it comes to the weaknesses of your case, you can choose to either ignore them or convert the bad facts to good facts. And then you can also give an explanation for the bad facts. Yeah, I believe that's what the opening statement entails.
Good, Krista. Now we'll give the answer pursuant to the landmark case of City of Hippo versus Desmond Peters and Faith Mweni. So these are a very potential question that you can be asked during the orals. And as you can see before your screen, we have various elements of an opening statement. And you will start with the presiding officer will give the introductory remarks, and then the plaintiff or defense counsel will introduce themselves, witnesses, and relevant places or items that they want to rely upon, and the counsel introduces the theme. This is important because from your answer you have only focused on introducing yourself, but you have not touched on a theme. A theme is a summary of what the case is all about, to capture the attention of the judge. Now, of the court, you go to the body. So there is an introduction, then there is a body. The plaintiff counsel will briefly summarize the facts, applicable law, the evidence, and witnesses. Up to this point, you have correctly captured the same. And the defense counsel may acknowledge harmful facts but frame them to support the defense. So I'm giving you in both the plaintiff side and the defense side at the same time. Then both will outline their case theory and themes, and they will identify the issue on mistaken identity and malicious prosecution, as was seen in this City of Hippo versus Desmond Peters and Faith Mweni. Then you will have a conclusion. The advocate will reiterate key issues the remedy being sought, and why the court should rule in their client's favor, and ending strongly with the theme. So, Kista, if you encounter a panel that has a lecturer in trial advocacy, and you omit to say the 3 elements of an opening statement, believe you me, you are going to fail that question terribly, because they will be keen. Have you even told us about the theme? Because if you are keen, the theme of the case is even mentioned in the body, and then you finish with it strongly at the conclusion part. So be keen on the opening statements. Let me see whether we have a closing statement. This is all about okay. So let me research on a closing statement, unless Albert can spare the day by telling us the essential features of a closing statement, so that we see whether there is a disparity when it comes to opening statements and closing statements, because that is a very potential question. Then Kista, because Albert is still not in, have you heard the case of King Woolen Mills Limited? Yes, Albert, you can clarify. Closing statements, then you tell us the case of King Woolen Mills versus Kaplan, what the case is all about. Why is it a landmark decision?
Okay, thank you. Allow me to first give a trial on the closing statement. I believe, unlike the opening statement, in a closing statement, the counsel is required to briefly give a wrap-up of whatever the case was, and something that is unique, which is not in the opening statement. In the closing statement, you have to make it clear what your prayers are to court, because keeping in mind that immediately after the closing statement, you have to establish what's your purpose or prayers before the court. Unlike in the opening statement, you just have to guide the court why it should determine whatever case is before them in your favor. So perhaps I can say one striking difference between the opening statements and the closing statement is on the prayers part and the final wrap up, without necessarily having the case theme. Yes, so that is my contribution.
Yes, thank you so much, Albert. Why is the King Woolen Mills decision a landmark decision?
The King Woolen Mills versus Kaplan and Stratton. Okay, I know it's a landmark decision in professional ethics, touching on the concept of professional negligence and confidentiality. I think I need to acquaint myself to the facts better, then I can get back and give my thoughts.
Thank you, Albert. Kista, can you save the day? Why is the King Woolen Mills decision a landmark decision?
Okay, I guess I can try. In the facts of the case, Kaplan and Stratton was representing the appellant in that case, and then he was also the law firm was also representing the financier who had given facility to the Kaplan and Stratton. So after some time, the financier came to Kaplan and Stratton. So Kaplan and Stratton was representing both the King Woolen Mills and the company which had given facility to King Woolen Mills. And now the issue was whether Kaplan and Stratton would represent the bank in a subsequent case with King Woolen Mills. So the court held that they wouldn't do that because there was a conflict of interest. and Kaplan and Stratton already knew information about King William Mills, which would be prejudicial to them if they proceeded to represent the bank. Considering Kaplan had also taken part in drawing the charge that was used in the transaction between the bank and King William Mills. I believe that's it, though I'm not clear with the fact.
Thank you so much, Kista. The reason we are here is to cast away any doubts. I'll read out the case and the key principles that you should take away. So in King William Mills Limited, formerly Manchester Outfitters versus Kaplan Stratton Advocates, the Court of Appeal held that a firm of advocates who acted as common counsel for both borrower and lenders during a loan transaction were disqualified from later representing the lenders against the borrower in related litigation. And the fact, as you have correctly put it, is that Kaplan and Stratton drafted the loan and security documentations and advised both parties, acquiring insight into the borrower's financial position. The lenders later engaged the same law firm to enforce repayment. And the law said that the court applied general fiduciary principles and common law conflict of interest rules, citing United India Insurance and versus others, to determine that prior confidential knowledge generated a conflict. A common advocate cannot act against a former client in the same transaction if privileged information was obtained, unless full informed consent is given. And the key principle from this decision that you can get is that the judgment underlines that while one advocate may represent multiple parties in a transaction for convenience, fiduciary duties persist indefinitely, and using confidential insights to advantage one client against another breaches those duties, calling for disqualification where such conflict arises. So you are correct that this is a landmark decision when it comes to conflict of interest in professional ethics situations and generally litigation and conveyancing matters. Now, Albert and Pluto, can you declare whether you are in a position where you can be asked questions, or I continue to grill Will Kista? You don't want to be grilled.
Okay, we have not personally been grilled per se, so you can just throw any.
Okay, let me throw in Albert. Have you heard of what we call a Chinese wall? What is a Chinese wall, Albert?
Hey, kindly pass it to Kista.
Kista, give me the definition of a Chinese wall. It is a principle that has been applied in a Court of Appeal decisions, and it was applied after the King William Mills decision. So it is testing you whether you have mastered the growth of jurisprudence in Kenya.
Okay, I guess I can try. Chinese is a principle where advocates in the same law firm can represent, let's say an advocate represented a client previously, and then, okay, let me recollect my thoughts and restructure. Okay, let's apply it in the case, for instance, this one for King William Mills, where Kaplan had represented King William Mills and the bank which had given facility. Now, the Chinese wall will come in, whereby if one client was the one who had represented King William Mills in that particular transaction, then King William Mills wouldn't claim conflict of interest, whereby the other advocate who is now coming in to represent the bank in the same in another litigation case never had contact with the advocate who represented King William Mills when they had entered into the charge with the bank. I'm not sure if I am correct. Whereby Chinese wall ni kama, acha ni explain na Kiswahili naone kama maybe ni Kizungu. Ni kama
China tutaelewa.
So, ni kama kuna advocates in a law firm but wako in different departments. So kama huyu advocate ali represent a particular client in a different case, and then sasa kuna client mwingine amekuja akapeana kesi yenye sasa huyu client mwenye wali represent kwa hiyo firm ndiye atakuwa adverse party, but sasa hiyo brief imepeanwa kwa an advocate in another department, then hiyo Chinese wall ita come in whereby huyu client akuna huyu advocate at this other department na this other department never discussed about this case, so this other advocate is not aware about the fact that zilikuwa zinaendelea in that other case yenye sasa the client ndiye amegeuka kwa the adverse party. I believe nimejaribu ku explain in the best way possible.
Kista, you have correctly gotten that principle. That is the definition of a Chinese wall principle, and it is used as in situations where the court has seen there was a conflict of interest, so they will go to the extent of analyzing the various departmental arrangement of that law firm, where you use different emails, how is your law firm structured, what are the mechanisms that you had incorporated for you to say that there was no exchange of information on a certain matter. Now,
Victor,
yes,
before you proceed, kuna hii case yenye walikuwa wamequote hapo kwa hiyo King William Mills yenye walikuwa na discuss hiyo Chinese wall. Ilikuwa inaitwa je case ni Rukusen versus Ellis na pia Rakwe versus Ellis. So in this case hiyo Rukusen versus Ellis kulikuwa na huyo advocate alikuwa anaitwa Mr. Monday alone acted for Rukusen separately and independently with exclusive knowledge of Mr. Clark, who was on holiday and unaware of the communication between Mr. Monday and Rukusen. The court held that there is no absolute rule that a solicitor who has acted for a person can never act against that person in future. The test is whether the court is satisfied that real mischief and real prejudice would result if the solicitor is allowed to act. Injunction ikakuwa refused. So basically in this case, Monday na Clark were in the same law firm, and then sasa huyu Rukusen akapea huyu Mr. Clark a brief. During that time akapea Mr. Monday brief. During that time Mr. Clark was not around. So later Rukusen akaclaim kulikuwa na conflict of interest whereby Mr. Clark alikuwanga amepewa brief yenye ilikuwa against huyu Rukusen. Akasema juu walikuwa na work pamoja kulikuwa na conflict of interest. So court ikasema juu walikuwa hawaja communicate kuhusu hiyo kesi, so hakuna venye Mr. Clark angejua facts about cases za Rukusen juu wako wamediscuss na huyo Mr. Monday. So court ikakataa kuissue hiyo injunction yenye Rukusen alikuwa na seek. I guess hiyo ndio hiyo Chinese wall.
Wow, thank you so much, Kista. So this tells us that you are very well read, even when it comes to the exceptional situations that somebody can try to use it to sweep you off the floor. So, Abigail, are you in a position to confirm whether you can be put in cross-examination?
Yes, yes.
Thank you so much. Can you kindly tell me where a person can use chamber summons? Just only 4 instances that a litigant can approach court, not as a way of institution of a suit, because it cannot be used to institute a matter, but give me the various situations where you can use a chamber summons.
One of the ways chamber summons can be used according to the civil procedure rules is when you are making an application for temporary eviction. Yeah. And then the second instance is where you want to add, or okay, where the second instance is where you want to make an amendments to the in regards to the parties. So either you want to make addition, substitution, or removing. This is in line with Order 1. The other instance where chamber summons may be used is where you I remember when we were being taught about judicial review, before people resort to use constitutional petitions for judicial review. Before, people used to have they used to use chamber summons to seek relief from the court to apply the orders such as certiorari, mandamus, or prohibition. And the other method, the other way I can think of is where you an application for garnishes proceedings, or charging orders. So where you want to make an application for garnishes, or and I believe everyone knows the garnish proceedings or charging orders, you can use a chamber summons.
That is well captured, Madam Abigail. You are well read, because chamber summons is to be used where it is specifically provided in law, and those circumstances also form part of the same: seeking leave in a judicial review process, joining a party as an interested party, and seeking leave to institute default judgment against the government. All those are the various situations that you can cite. Now, Madam Abigail, you are an examiner pale CLE, and you have found a student struggling so much to know the difference between Anton Pillar and Amareva injunction. Do you know the grounds that that student should seek so that he will not fail that examination in both applications?
Yes, I believe I am a bit well versed with Anton Pillars and Mareva injunctions. Maybe to start with the difference. Okay, these are I would say equitable remedies, which okay, the difference is Mareva injunction. It is mainly an application or an order that freezes a defendant's asset to prevent them maybe from hiding, disposing, or wasting. And then an Anton Pillar allows a plaintiff to maybe enter premises to search for critical maybe evidence. But according to what I know, it is mainly given in matters of intellectual property. So the grounds for, if you want to be granted Mareva orders, which I believe they are provided under Order 39, and in line with the Civil Procedure Acts. One of the ground is definitely you have to have a good and arguable case. So you must demonstrate that in your claim you must demonstrate that maybe that property you want to you want the court to maybe prevent it from being wasted is actually at the verge of being wasted, or that defendant is is maybe is in the process of selling that property. I think I'm just thinking that line. So number one, you must have an arguable case, a good arguable case, and then number two, the assets have to be within the Kenyan jurisdiction. From the cases that I've read on Mareva injunctions, the asset has to be within the confines of the jurisdiction of the courts. And then number three, you have also to show that there is that risk of wastage, dissipation, and I think this is one of the solid grounds that you can. I think this is where everything
You are breaking, Abigail. Abigail, you are breaking. Amani, from my end. Can you confirm I'm audible? Abigail, we have lost you. Because Abigail had correctly captured the main test for Mareva about jurisdiction and a good arguable case, Kista, can you spare the day by telling us the key identifier for Anton Pillar orders?
Maybe we can have Albert.
Albert, can you save the day?
Just to try. But I think Abigail has already exhausted all of them. What was the question, really?
The difference between Mareva and Anton Pillar injunctions. Yes, the difference, the key identifier.
Okay, we can say the difference as to purpose. Number one, as she has already put it, for the Anton Pillar orders, they are usually orders sought by an applicant to enable them to at least enter into a premise and search ordinarily without informing the subject. And mostly they are applicable where the information to be found out is such in a way that it is incriminating to the subject, such that if they are requested ordinarily through the normal way, they won't avail them voluntarily. So they have to be compelled or ambushed such that the information sought to be relied on can be obtained and be used for determination of a matter. So in short, it is for such. It's like a form of a warrant to search, right? On the other hand, the Mareva injunction, as she has rightly put it, the other word for Mareva injunction is freezing orders. They are mainly sought to allow a property or anything that is in possession of the subject or the person whom the orders are being sought against be freezed or protected from being taken out of the jurisdiction of the country pending hearing and determination. For instance, if a party is brought into a suit and the plaintiff has reasonable grounds to believe that by the time the suit will be fully determined, the defendant will have disposed of or done away with the property which forms the subject matter of the dispute. For instance, I remember there is a question, I think in 2024, 2025, where the facts were that a Ugandan citizen caused an accident around Parklands area in Nairobi, the car was registered in Uganda, number plate, right? The guy had just come to Kenya for a conference, a 3 days conference, then caused an accident. So everything was booked, the details were taken, but the time limit for the defendant was almost running out, and the plaintiff had reasonable grounds to believe that once the permit for the defendant runs out, he will have to go back to Uganda, and probably he will use that car, which forms the subject matter of that claim now. So in that circumstance, I believe the examiners were trying to invoke the mind of the student now to apply the Mareva injunctions, such that the subject matter of that suit, that is the motor vehicle, cannot be allowed to get out of the jurisdiction of that matter, because execution will be very impossible if we don't have the subject matter. I really don't know if you've targeted another very specific difference. And then these orders, by the way, they are mostly discretionary. You really have to prove a very contingent case. They are not, they are applicable on a case-by-case basis. So I'm not sure if I've really brought out the difference as you were expecting, but that is
Yes.
to the best of my knowledge.
That question has correctly been answered by both parties. I was looking for the key identifiers, even by the fact that you have even given a scenario that shows you have a good mastery over the same. Now, Albert, you have received a client on probate and administration issue, and this client has approached you with a foreign grant, and he tells you directly that he seeks you to revoke this foreign grant. Now, can a foreign grant be revoked in Kenya? Time, Albert, time. Remember, kuna 10 minutes. It's yes or no? Albert, you may pass. Can a foreign grant be revoked in Kenya? Albert amepotea. Kista?
I'll give it a try. I believe the way you follow the process of the foreign country to obtain the grant, that's the same process you're supposed to follow for revocation of that grant. So you can't seek for revocation of the grant in the Kenyan jurisdiction. You have to go back to the foreign country where you obtain the foreign grant from.
What is the rationale of your answer? Is it a statute or is it your reasoning?
But now it will depend. If you had already done the process of resealing under Rule 42 of the Probate and Administration Rules, and is it Section 77? Then in that particular case, you can revoke that grant under the Kenyan jurisdiction, because at that particular point, then it means the grant had already been inculcated into the Kenyan jurisdiction and Kenyan laws. But before that, then I believe you have to go back to the jurisdiction where you obtain the grant from. For that, I don't have a statutory basis.
Thank you so much, Kista. It is the Law of Succession Act, one of the sections, I'll confirm, that has directly prohibited one from resealing, not resealing, from seeking revocation of a foreign grant. Now, to the extent that this grant has been resealed in Kenya, and then the same has been adopted in Kenya, I'll have to confirm with authorities, or unless you have an authority to back it up. But before we start our next orals, that will be the key clarification that we will have to make. Is that in order? Yes, sir. Abigail, Does the Small Claims Court in Kenya have the jurisdiction to determine material damage claims resulting from an accident?
I'm not really sure about that case, although I have a bit information based on the judgment that was given. I believe this this year. Yeah, this year, at the beginning of this year, and the the judgment sought to I'm not really confident with my answer because I'm not really sure about it. But I know as of that judgment, the determination was that small claims had no jurisdiction with matters to do with accidents, and so they cannot, based on that judgment that it was given this year, small claims cannot award material damages. Although someone can just tell me about it, I'm not really sure about it.
That is well captured. I will save you. Pluto ako incognito or Pluto Pluto hapana. Kista. Save the day. Does the Small Claims Court have the jurisdiction to determine material damage claims from an accident, from a car accident?
Okay. And as the jurisdiction of the Small Claims Court is provided for under Section 12 of the Small Claims Court Act, which provides that the Small Claims Court will preside over matters below 1 million, which stem from contractual obligations, basically contracts. So personal injury claims don't fall under the Small Claims Court Act. We had the decision that was made earlier this year, where the court stated that the Small Claims Court doesn't have jurisdiction over such matters, over personal injury claims, but I can't quite remember the name of the case, but I know that's the position.
Thank you. I'll now clarify the reason why I've avoided Simon and Albert because they are experts in those fields. Now, there was a three-judge bench they're sitting at the High Court level where they determined that the Small Claims Court will not have jurisdiction to hear personal injury claims arising from car accidents, but they never restricted material damage claims. Material damages now, this is why you are approaching court to claim damages on for the vehicle, okay, for the vehicle, not a personal injury matter, because Small Claims Court are still entertaining court matters on material damages claims. That was the key identifier. And once I've asked you deliberately on material damage, it shows that students will rush to say that the decision laid a blanket rule to both personal and material damage. Now, I also have another question. Let me clarify. I'm looking for one that will trigger something. Can you kindly give us at least 3 names of current Court of Appeal judges?
Is that question directed to me or
any member? That is an open-ended question. In fact, one can Google to also answer the same.
I think I can go. I can just mention 2, and then the other ones can give. One, I think I remember those that were sworn this year, and one of them was Justice Keegan Katwa and Justice I don't remember the first name, but it's called Radido, Anderson Radido, and Chacha Mwita. Yeah, those I can't remember.
Thank you so much. I also have a list with me. Justice Gatembu, Justice Patrick Kiage, Justice Fatuma Sichale. Those are also judges of the Court of Appeal. Now, another question. I'm sieving through the materials that I have to see. What is the difference between a surety and a recognizance? Any member? The difference between a surety and a recognizance. Bill Kister?
Okay, I'll try to answer that. For surety, these terms apply in bail and bond applications. So a surety is a third party who undertakes to ensure that the accused person attends court, and by doing this, they give either bail or bond to guarantee that they will ensure that the person, they give security to guarantee that the accused person will attend court. Recognizance, on the other hand, is where the accused person gives either cash or a title deed to undertaking that they will attend court. Yeah, that's my answer.
You are correct to the first part on a surety, where you are using another person, and that person will either deposit a title or they will also issue out themselves to make sure that you duly attend. It's a personal surety that they will be asked on your whereabouts. But for recognizance, this is where Will Kister is the accused person, and they are telling the court directly that, hey, look, I'll just avail myself. Whether you require me at any given time, I'll come. So for you to be given a recognizance, there are some tests that can be conducted, and for it is rare in Kenya, but it is usually given to prominent and distinguished individuals because the court is relying on your words that you will avail yourself. That's the key difference to the same. I'm looking for another one. Who approves the defense of an alibi? To whom is the burden of proof of an alibi attached to? Mr. Chadwick, welcome. To whom is the defense of an alibi the burden of proof attached to? Is it the accused or it is the prosecution? Mr. Chadwick, you can start with that as your opening statement.
I think the defense of alibi is attached to the accused person, and something to note that it should be raised in the first instant, so that to enable the prosecution to conduct further investigation to ascertain if indeed the accused was at the scene of the crime.
So in your view, there is a time where the burden of proof beyond reasonable doubt will shift, and one of the exceptions is the defense of alibi.
Yes, it will shift if the accused person raised the defense of alibi. The burden of proof now will shift to him to ascertain, to confirm that indeed he was not there, and this will include corroboration of evidence or other witness present.
Pluto is an authority in criminal matters. Pluto, is that averment the correct position? Can the burden of proof in a criminal matter shift to the accused person when it comes to alibis?
Yes, thank you, Victor. The rule of the thumb is that he who alleges must prove. I believe that's the starting point. And in any proceedings, whether civil or criminal, the onus is always with the person who alleges. The only difference is that in one side, one is beyond reasonable doubt, and on the other side is on balance of probabilities. Therefore, I believe that if now the accused person raises the defense that I was not at the scene, now that's what we call alibi, then the burden will automatically shift to him who is alleging. Maybe you can guide us on that, but I believe that should be the position.
Okay, in my view of, okay, yes, Phil Kister?
Maybe to add on what Pluto has said, what shifts is the evidentiary burden of proof, but the legal burden always stays constant, and the prosecution counsel never shifts. Yeah.
Yes, that is the answer that I was looking for. There are authorities to that it is only the evidential burden that it will attach to the accused person. Do you have the receipt to prove that you had boarded on a bus? Those kind of questions. But for the general angle of it, the accused can just say, I was not there at the scene of the crime, and it is the onus of the prosecution on the legal burden of proof now to prove that that averment is false. That is how you should begin when it comes to that angle.
Maybe Victor, you can and what's the difference between the legal and the evidential part? Maybe Kista can guide us.
Let Kista go first.
Okay, let me try and answer that. The legal burden of proof is the burden that the prosecution has to ensure that they, allow me to use the same words to define, it is the burden that the prosecution counsel has to prove the case beyond reasonable doubt. So this burden lies with them throughout the case. It never stops. So throughout the case, the prosecution has that duty to ensure that they prove that the accused person did the particular offense as is being claimed beyond reasonable doubt. But now evidentiary burden of proof comes in where the accused person claims maybe they were acting in self-defense, or maybe they claim a defense such as alibi, Bataduman syndrome, such defenses. So in that case, the evidentiary burden of proof, which also lay on the prosecution before, together with the legal burden of proof, will shift to the accused person to prove that they were, maybe if it's the defense of alibi, then the evidentiary burden will shift to them to show that they were not at the place of commission of the offense. And the standard of proof for that now will be on a balance of probabilities, just to raise a doubt on whatever the prosecution counsel was alleging. So I believe I have been able to answer your question, but that's how best I can do it.
Thank you so much, Kista. I'll also direct the participants to read the case of Wesonga versus Republic. It is a court of appeal sitting at Kisumu in 2023, Wesonga versus Republic. And this decision is a very critical decision because it tells us that there is no point where the legal burden will shift to the accused when he raises the defense of alibi. But there is one point that Chadwick said, and I will borrow it as per this decision. It says that the accused person has the evidential burden to plead alibi at the earliest opportunity time. Okay, that is what the decisions have tried as much as possible to say. And why is the evidential burden placed on the accused person? Because failure to plead the evidential burden, and he keeps quiet. Remember, you have the right to remain silent, but it is to your advantage if you back up your position with evidence. That is when you will prove that you are not there at the time of the commission of the offense. So it is only there to save your soul, but the legal burden will now always stay with the prosecution. That is how I could have also tried to explain the same, but I'll go deeper. Maybe one of the key takeaways that we have said, we will come with full answers. How do you conduct a proper closing statement? Because Albert answered the same. An opening statement, we have discussed the case of City Hippo, a landmark decision that you can be asked, and the law is settled when it comes to the opening statement. That is the key takeaway. Another key takeaway that I've borrowed here is I'll have to analyze where it comes to now the exact difference between evidential burden and the legal burden of it with examples. That is what I will have to confirm. Now, this is a closing question. I want to confirm that you don't cram decisions that bear the jurisprudential value in Kenya. And I'll start with Mr. Shem, welcome. This question will go to you. Kindly give us the various tests that have been applied in the case of Giela versus Kasman Brown. I have a reason why I've asked that question, because I'll do a follow-up question from that. First, start with the three conditions that were laid out in the Giela versus Kasman Brown.
I'm sorry. I'm not so, but I think I just read this case recently. If you can only tell me what it's about, then I can. I don't think what it's about precision of a constitutional petition, but I think it's about elements. It talks really about. Just tell me what it's about, and then I will tell you everything.
Injunctions.
Very good. Okay. All right. Yes. When you're seeking an injunction, first things first, you must prove that if the injunction is not granted, that then the person or the person seeking the injunction will suffer irreparable harm. That, for example, cannot be paid in terms of money, but the person will suffer loss or harm that is irreparable. And another thing is, apart from that, maybe the case that the person has chances, very good chances at the prima facie of it, that of succeeding. I don't know. Those are two things I can remember. Please let me know more about it.
Thank you, Mr. Shem, for trying it out. Let us read out first the test. The applicant must show a prima facie case with a probability of success. Irreparable injury, which will not be adequately compensated by an award of damages. That one you have correctly gotten it. And if in doubt, the court will decide the application on a balance of convenience. Now, Madam Charlene, before we came to GIELA, there are some 3 core decisions that form the tests laid out before you. I want you to give me the name of the decisions plus the test that they helped in redefining the GIELA versus Kasman-Brown.
Good evening.
Each decision per test. Yeah.
Okay, good evening. Thank you so much for the question. However, I'm not familiar with those 3 cases which laid down the tests that informed the decision in GIELA versus Kasman-Brown, and probably I'd appreciate if you give me insights on this theme.
Welcome, Mr. Shalim. Any member who can save Madam Shalim? Chadwick?
Maybe, pardon the question.
I've said, when GIELA versus Kasman-Brown is cited, people only see the 3 decisions before them, but they did not understand the various decisions that existed, and they helped to redefine the mandatory conditions laid out in GIELA versus Kasman-Brown. So behind the scenes, we have core decisions, and each decision played a part in redefining the elements that you see before GIELA versus Kasman-Brown. What are these decisions, and to what extent did they help in redefining GIELA versus Kasman-Brown?
Okay, there's a decision called the Nguruman. It's Nguruman versus, I'm not sure the proper citation, but something that Nguruman case assisted in defining the GIELA versus Kasman-Brown condition is that the conditions are to be applied consistently, in that if you fail to meet one of the conditions set out therein, your claim for the injunction lapses. That is, if the applicant shows a prima facie case but failed to show the irreparable injury test, then the case collapses. So they should be applied strictly in that order. That's what I can remember.
Thank you so much, Mr. Chadwick. That is one of the decisions. There is one other decision. Any member who can have known it? This is the decision known as the Mrao decision. Mrao Limited versus First American Bank of Kenya Limited and 2 others. And the key takeaway from the Mrao decision is that it proved to define what we call the prima facie case. And the court defined this as more than just an arguable case. That is the key takeaway when it comes to the Mrao decision. It helped to redefine a prima facie case to an extent that you don't just say this is an arguable case. And that is the reason why the GIELA versus Kasman-Brown indicates you must show a prima facie case with a probability of success and not an arguable case. That is the key takeaway. Then we mix up with Chadwick's answer. So at this point that we have arrived at, this is the point where I usually ask the members to reveal the hardest questions that they have at the back of their minds. They pose to us so that we also try to answer them. And by the hardest question, I believe this is the question that you believe you are the only one who has that answer, so that we also attempt it, because you are only left with 20 minutes to go. So the floor is yours. Yes, Mr. Chadwick.
Okay, just to take you back, the Nguruman case, maybe if you can assist me get the exact parties. Suppose you are asked in an exams.
I'm confirming the same. I had it in mind. Let me look at the exact parties. Let me Google. The case is known as Nguruman Limited versus the Attorney General and another. Is it the case kweli? Unajua Nguruman wanaweza kuwa wengi.
Is it a Ugandan case?
I'm confirming. To be honest, I must confirm for you pole pole. Zinatoa Nguruman mingi. I can mislead you.
Victor.
Yes.
Inaitwa Nguruman Limited versus John Bonde Nielsen and two others. Civil appeals.
Which year?
2012.
Nice. You can come again so that kuna mtu hajaelewa nimeinterrupt.
Nguruman Limited versus John Bonde and two others. Civil Appeal 77 of 2012. It's a Kenyan case.
And for the Mrao one, it is Mrao Limited versus First American Bank of Kenya Limited and two others. The year is 2002. Now the panel, the floor is yours, guys. Just ask the hardest question that you believe you have at the back of your mind. It can even be a current affair.
The types of files in a criminal case. If we can just suppose tomorrow is an oral question and they ask outline the files in a criminal trial.
Choose a member.
I can't even see them. Let me see. Let me take Charlene to be assisted by Martin because of the gender balance.
Ni kama watu hawajasikia Chedwick, you can repeat.
I'm saying in a criminal trial, the types of files that the prosecution files in court from A to G, I think A to G. So the files that are being opened by the prosecutor.
Or maybe you can put it in this way. What are the contents of the prosecution file, the defense file, in that manner?
If I may, Victor.
Yes.
Could Chadwick be referring to the police file and not prosecution files? Because I'm aware file A to G, they refer to the police files.
Chadwick, I had like you mentioned my name.
Yes.
You wanted me to assist on that question?
Yes, I chose you and Charlene.
Okay.
So you have to balance mtu akishindwa mwingine anachukua.
Okay. Because okay, fine. I think for the prosecution files, as much as I understand, before a charge is brought to court against the accused person, of course they must be having that police file. I mean the prosecution file that has the police file with the written sub-files. A that has it has the occurrence book. That would be. Am I wrong? Am I right? not too sure. Then you have B that has the documents, the sketches. Then C, I think, has the is it the expert? Is not the expert, but of course the victim statement. Then you have one which I'm not too sure it is D that has the expert, like if you have the P3s and all those kind of things. So then you have the witness statements. I'm not too sure which order, but then you also have the one of the files that has let me see. It has the, of course, we have the. Have I talked about the victim? I mean the of course the witness statement. We have the IO diary in terms of where they're going to be able to diarise what they're doing. Then we have also the investigative report that comes in at the end, and of course the charge sheet and the cover report. I'm not too sure the order, but basically that. But also I know there is also the court file that more or less mirrors what the prosecution has. So which the court is going to be able to use to be able to generate its own records as well. And basically, I think those are the files that I maybe I could. Shalin can be able now to help me out on the others. Thank you. Over to you, Shedik.
Okay, thank you so much. Maybe if we can just clap for Martin. Because he has tried so much. Albert, you wanted to add something? Albert.
Oh, thank you. Perhaps just a small idea, if I can share with you on how to capture them, but it captures only the first 5 files. You just say the word ideas, right? Then from letter I is the initial report, D is the documentary evidence, E expert testimony, A accused statement, then S we have subfile S. Let me refer. Yani ukishasema tu ideas hivyo ukichanganya you can get at least the first 5 files. I'm trying to create another acronym for the last 5 files, then I'll share with you.
That's a good one. Anyone else? Okay, Sharon is saying that you repeat. So, Albert has said you use a short form of ideas. So, you said I is the initial report, D is documentary evidence, or maybe Albert, if you can just come up again. Albert.
Oh yes, sorry. My body has some problems. I'm saying if you write the word following, I is the initial report, that is file A. D is the documentary evidence or documents to be relied on. Then E is expert testimonies or witnesses. Then A is the accused statement Then S in the word ideas they are usually the general statements that shall be given by other persons apart from the accused now. Then you now finish with the ones that had been given before. I'm still looking for an acronym for that. I don't know if that will help.
Thank you so much, Chedwick Albert. And now, Chedwick, when we resume our session tomorrow, you'll be the one to take up the stand to clarify on the other types of files and their contents. And also, in addition to the police file, we called a DCI who presented the same with pictures, with actual information also, and we uploaded the same in the channel, so you can also add that as you follow the mnemonic listed down by Albert. Then another closing remark is that we have borrowed some key takeaway assignments that you can also go and have a look at it. I told Kista that the Law of Succession Act prohibits, it says that directly you cannot seek revocation for a foreign grant, but Kista now brought an idea where the grant has been received in Kenya and thus it has been adopted in Kenya, and that is an exception where it can be revoked in Kenya. So we said that we go and analyze that amendment and come with clarification on what decisions are saying. The second assignment is on the difference between legal versus evidential burden of proof when it comes to the defense of alibi, because the law is settled that prosecutor, the burden of the legal burden of proof always does not shift to the accused. It stays with the prosecution when the accused person brings out the defense of alibi. But on the other hand, the law says that the evidential burden to prove the defense of alibi lays with the accused person at the earliest opportunity time possible. Also give us the exceptions if the accused person decides to bring it out later during trial. Then also the last key takeaway that you have seen is kuna key takeaway ingine tumesema tunaenda kuangalia. If somebody can remind me, I'll also revisit the recording to confirm the takeaway. Yeah, up to that point, I leave the floor to closing remarks because we are only left with 5 minutes. Any member can also save the day by commenting, asking key takeaway provisions where you want people to go and research, then they'll come with clarifications. All right, if there is no any comment, I'll tend to now declare the meeting officially closed. I'll upload the same in YouTube immediately after I've cancelled the recording. So there is no more information from me. Have a good night, members. Unless, Albert, you have clarification, you have raised your hand. Okay, so thank you, members, for your participation. I greatly appreciate.
Thank you too.